Hello, welcome to those of you who are joining us. Give us just a moment while we let people in from the waiting room. Give me just a moment and we'll get started here. Okay, welcome everybody. Welcome to our webinar today. This is the webinar entitled Divorce 101, Everything You Need to Know About Divorce in Washington State. In just a few moments, I'm going to introduce Michelle Dellino, and we'll be diving into a lot of great information about the basics and the things that you need to know about divorce. A couple things just about this format today. This is a webinar and we're going to be delivering information, but we also want to be able to take questions. And so the way that we'll do that is if you have questions, please go ahead and enter them either into the Q&A or into the chat. And if you do send them into the chat, they'll just come to me. I have it set up so attendees can just only chat with the host. So you can send a question in the chat and I will pitch that to Michelle and we'll try to get that answered today. If you pitch a question in the Q&A, you'll want to mark yourself as an anonymous attendee. Otherwise, your name will show up. If you don't mind, that's fine. But just so that you know, those are the options of how to pitch questions to us. We'll answer as many as we can. Keep in mind that we can't answer anything that's too case specific. More general questions is what we'll be answering today. So just to introduce myself really quickly, my name is Melissa Rosenberg, and I am actually a therapist. But one of my specialty areas is working with clients who are navigating different phases of the divorce and separation process. I work with clients in my private practice who are in the early stages of trying to navigate divorce or trying to determine if divorce is their most, healthy path forward, or if relationship repair is a potential option. I work with clients who are in the middle of their family law case and navigating the emotional pieces that are involved with that. And also clients who are post-divorce and trying to navigate their next chapter and just trying to help them, be able to pave the way for that. Today I'm here as a moderator, so I will be answering questions, asking questions to Michelle through the chat, through the Q&A, and trying to get as much information delivered to you all as possible. So that's where we're at. And with that, I'll turn it over to Michelle to get started.
Hi, thanks for being here. I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we help clients all over Washington State. So I've been practicing family law for almost 16 years. That means that I've seen pretty much every kind of circumstance, and what you might think is crazy, we kind of think here is normal. So sometimes that means a case that's heavy litigation that's going to trial. Sometimes that means a case with a negotiated settlement. Oftentimes that means resolving a case through mediation. There's really a solution for every problem. So it's important for you to know that even if your situation feels overwhelming and you don't know what's going on, there's hope, and somebody's probably been in a situation just as crazy as yours. So what I'm going to do today, I'm going to give you some basics on divorce in Washington State, what it means, the issues to know. I'm going to talk to you a little bit also about what an attorney's role is in a divorce in Washington and what it's not. We're going to take some of your questions. Before we start, we should note that I am an attorney, but I'm not your attorney. So nothing that I say today is legal advice. If you want legal advice, you need to consult with an attorney, whether it's me or somebody else. You need to actually have something where there is attorney-client privilege. So this is just information. So you should feel free to take what you can from it. If you want to follow up with a consultation with me or anybody else, you should absolutely do that. Melissa will take questions, like she noted. It's very difficult sometimes for us to answer very fact-specific or fact-intensive questions. So we'll do our best, but if we're not answering your question and you're giving us a long hypothetical, that's probably why. So I hope that helps. So, well, as we talk about divorce in Washington, what are the requirements to get divorced in Washington? This is a very basic thing, but I think it needs to be mentioned. There's a residency requirement in Washington. So that means at least one spouse must reside in Washington State at the time of filing. In Washington, unlike a lot of other states, there's no minimum residency period. So a spouse can file immediately after moving to the state. If one spouse doesn't live in Washington, then you need to talk to an attorney to find out, is there jurisdiction over the other party, over the property? What's the situation there? Because just because one party can file here doesn't mean there's jurisdiction over the other party. And what is jurisdiction? You might hear that word during your divorce process. Jurisdiction means the ability and the authority for a court to enter an order over the other party that forces them to do something or to do something with their property. Jurisdiction over the children is another thing. If you move to Washington and your children haven't been here 6 months, there might not be jurisdiction over them. So the threshold to being able to move forward with the divorce in Washington is low. You just have to move here, live here, establish residency and file. But whether that's going to work for you in your case is going to depend on the particulars. That's the residency requirement. Grounds for divorce. Who can get divorced and why, right? So Washington is a no-fault state. Most states are. Fault in divorce is a pretty rare thing, although a few states still do have it. So what does it mean to be a no-fault state? It means if somebody has an extramarital affair, if somebody takes money, if somebody commits domestic violence and is abusive, you don't have to have a ground like that to be able to get a divorce. Anybody can get a divorce. The only grounds that are required is that you are claiming the marriage is irretrievably broken, which means it can't be repaired. One party believes that, and that is enough. Sometimes I get clients where they got served with divorce and they don't want it. And they're like, well, I don't want to agree that the marriage is irretrievably broken. I want to fix it. I don't want to get divorced. And I totally understand and relate to that. And that might be true that you don't think it's broken. But if one person thinks it, that is a unilateral action that they can take. And you can't actually contest the divorce and say, no, I want this person to stay married to me. That's not an option. So there's no need to prove, just to summarize, no need to prove any wrongdoing, no need to prove fault. And both parties do not actually have to agree that the marriage is irretrievably broken, just one person. So I hope that helps. What is the waiting period? How long does it take to get a divorce? Everybody wants to know that. So I'll tell you what the waiting period is. And then I'll tell you like what's realistic. So the waiting period in Washington, and this is different from a legal separation. There's no waiting period in Washington to finalize a legal separation. I'll come back to that in a minute. But in Washington, there's a 90-day waiting period after filing in service before a divorce can be finalized. What that means is you file your divorce, you have the other party served, or they sign what's called an acceptance of service saying, hey, I got the paperwork. And then it's 90 days from then until your divorce can be finalized. So on the 91st day, the court will look at the final divorce orders if you have them, and they will sign off on them. If you come to the court with totally agreed orders and it's been 60 days, the court's going to say, no, you got to come back at 90. They don't have the authority to enter a divorce until that 91st day. So that is what the minimum is. This period allows time for negotiation. Some people might reconcile, whatever it is. There is a waiting period. Some states have longer waiting periods. I believe North Carolina still has a year. Some states have 6 months. Some states have 30 days, but 90 days is a pretty reasonable time period. And why do I say that? Because that's a really fast divorce. Any case where there's disputes over custody, assets, support, or even if there's not necessarily dispute, there just needs to be more fact finding. Like, let's say you haven't had access to the finances. You need to see what there is. Let's say you have kids. You need to see what might work for a new schedule. 90 days is almost always too fast to get divorced unless you really have planned everything ahead of time, or you're really aligned, or maybe you didn't file until you'd negotiated everything, which is another approach you can take. So anyway, 90 days is fast. It can happen in some cases, but if you're negotiating those things, it's going to depend on how many things are you negotiating? How far apart are you? It's going to depend on what county you live in, because some counties have case schedules that will keep things moving along, some don't. So I would say a realistic time frame for a case in King, Pierce, or Snohomish counties where there's anything in controversy really is more likely 6 months on the low end to 18 months. So, and that does not even mean cases that are necessarily going to trial. That can mean cases that need a lot of discovery, need a custody evaluation, need more time for fact finding, need time to see what's working on a temporary basis. That can mean a lot of different things. And just because your case is taking longer doesn't mean it's not going to resolve in negotiation. Sometimes I used to tell clients this a long time ago, in criminal cases, they'd be like, well, I want my case over right now. Well, if you wanted your case over right then and it was a criminal case, the fastest resolution is not the best resolution, because that's going to be plead guilty. In like an analogous manner to that in a family law case is, well, if you want it over right now, you're going to take whatever the other side's offering without knowing everything, without knowing what's best for your kids, and without really having an opportunity to negotiate. So the fastest result is not the best. We like to tell clients this is really a marathon and not a sprint, and you need to pace yourself for the marathon. There might be times when you need to pick up the pace. There might be times when you need to coast, but that's really what it looks like. A legal separation, I mentioned this earlier. I'm going to mention the waiting period again there. There isn't one. So what does that mean? There is a waiting period to take a legal separation and make it a divorce, but you could finalize a legal separation without a waiting period. And that would be doing everything you're going to do in a divorce. You get a parenting plan, you get child support, spousal maintenance if it applies, you divide debts and assets, you do everything that you're going to do, and you are legally separated at the end of that case when you get that final order. But you're still married. So sometimes that means you could keep somebody on insurance. Other times it doesn't. It depends on your employer's policies, but you're still legally married. However, either party can convert that legal separation to a divorce, and it takes 6 months. And all you have to do is wait 6 months from the time you finalize that legal separation, and then either party can file a motion to convert it to a divorce. So that can happen. It's sometimes a slower way to divorce. Some people do legal separation for benefits reasons. Some people do it for religious reasons. Some people do it just because it's easier to get the other party to agree. So anyway, I hope that that helps. Melissa, any other questions that you have so far before I move on?
Sorry. Yes, I think somebody's looking for a little bit more explanation around the difference between legal separation and divorce and kind of how what comes up. What are some of the other differences that might come up there?
There are no other differences. So we just kind of covered most of those. The only differences are you're still married, you can't marry somebody else, and you can't convert it to divorce for 6 months. So, but all of the things happen. The four primary things that happen in a divorce happen in a legal separation. Assets and debts are divided. Parenting plan if you have kids, child support if you have kids, determination on whether there's spousal support, attorney fees can be awarded. All of those happen in legal separation the same way they do in divorce, but you're still married. So I hope that's helped. You'll even file taxes as single. So I hope that's helped. So far we've covered residency requirement, grounds for divorce, and waiting period. And I've given you a little bit of a preview on the 4 issues. Before I move on to talk about the first issue, anything else, Melissa?
Yeah, there's another question here, and it's a little bit of a specific situation, but I think there's pieces we can pull out to be more
Sure.
general. We bought a home together, but didn't have a prenup. Person doesn't feel safe in the divorce process, and has moved out. So they're wondering if they've moved out during the divorce process, can they still fight for child custody? Can they still fight for a share of their primary home after being married for 11 years? The child's used to the home. How's that going to be determined with custody?
Yeah, well, a couple of things to talk about here. And like I said, there's 4 main issues. The first one I'm going to talk about is property division and debts and assets. This person's bringing up a home, and was it last night? I think it was last night. We were on a meetup group that we do, and somebody was asking the same question. If I move out of the home, can I still be awarded the home? Do I lose rights to the home? How does that work, right? And that's kind of what this person's asking. This comes up a lot, so it's a great question that you asked. If the character of the property that you have, there's 2 kinds of property for purposes of divorce. There's community property and there's separate property. The character of the property is going to be, is it community or is it separate? That is decided at the time the home is purchased. If that home was purchased during the divorce, even if you're both not on title, there's a presumption that that's community property. That does not change later. That character of the home does not change later because somebody moves out of it. So you don't lose any rights if you've moved out, not at all. As far as who's going to be awarded the home, that it could go one of 2 or 3 ways. It could go to you, it could go to the other party, or the home could be sold. So who's going to keep the home is largely going to depend on your financial settlement and who can afford it and what makes sense as far as if your child, what makes sense for the child to stay in the home and what that's going to look like. But a lot of the time, especially in our area, what will happen is you have a home and it has a bunch of equity if you've owned it for a while, and there's not a lot of other assets. And if there's not a lot of other assets, there's not a way to make a transfer payment to basically resolve the case, then you might have to sell the home because you're going to need to divide the equity and you can't buy the other party out. So I'm not saying that's your situation, but to answer your question, it doesn't matter if you move out. It doesn't change any ownership rights. You either have those already or you don't. And as far as whether you're going to be living in the home later, it's going to depend on finances. It's going to depend on logistics, and so on and so forth. So I hope that that helps. And on that note, I think I'll talk about the first issue, which is asset and debt division. So this issue is in every case, you're going to have to deal with it. Asset and debt division. Community property. This is a community property state. You've probably heard that if you've started your divorce case or if you're just looking into it. But do you really know what that means? Because I find that most people, a lot of the time, even other attorneys, they don't really know what that means. So community property, that means the presumption of things being community property means that most property, assets and debts acquired during a marriage are owned by both spouses. It means you both have a community interest. What it means is that the name on the title of the asset doesn't matter. So if you are married and you got married 10 years ago and you have a 401k and you're going to your job every day and getting a paycheck and putting money into your 401k. The 401k is only in your name because you're the employee, right? But if you earned all that money during the marriage, if you don't have a prenup, then that says otherwise, then that money has a community interest. So your spouse has an interest even if they're not on the account. Vice versa, if your spouse has been earning money in their job and putting it into a brokerage account or whatever, you have an interest in that too if that money was earned during the marriage. So community property is any asset or any debt that's acquired during the marriage. And there can be exceptions to that. There can be reasons that something is or isn't community, even if it's acquired during the marriage. If you inherit money, like if you have a friend or family member die, or somebody leaves you money during the marriage and they leave it just to you and you keep it separate, doesn't matter if you have a prenup or not, inheritance by operation of law is automatically separate property. So you can change the character of that property by doing things with it or making it community, but it's automatically, without doing anything, separate property. So are gifts. If somebody gives you something during the marriage and they give it just to you, not you and your spouse, that is separate property as well. Then there is the question of income that is earned during the marriage. And these are just common scenarios. There can be others too. But if you have income that's earned during the marriage, and maybe it's from a business that you owned before the marriage, or very common is like, I have a rental house that I owned before the marriage. It's my separate house. I'm earning rental income from it. I'm earning that money during the marriage. That's still my separate property. That's not community because it's coming from a separate property source. But in general, any house, any income, any assets that you acquire or buy, and also any debts, any credit cards, any mortgages, anything during the marriage is presumed to be community. But what does that mean? It means you both have an interest. So once you figure out like what's in the community, and you have to figure out how to divide it. A lot of people think that community property is divided 50-50. Wrong. That's not the case in Washington. Sometimes maybe, but we're not a 50-50 state where everything just gets divided down the middle. We are what's called a just and equitable state. And what that means is that it's supposed to mean that the division of your property is whatever is fair. Now, fair means different things to different people, and I suggest that if you're going to be in the divorce process, you remove that word from your vocabulary because you won't feel like whatever's happening is fair. And the other party won't think it's fair either. So that's something important for you to know. So how does it get divided? A couple different things are going to be the primary factors. How long is your marriage? Is it a short-term marriage? So the duration of the marriage is a big thing. Is it a long-term marriage? Is it a midterm marriage? Short-term marriages are 5 years or less. Midterm marriages are basically everything from 6 years on up to 24 years, although the degree of the long-term marriage, I'm sorry, the midterm marriage can vary. And long-term marriages in Washington are by definition of law 25 years or more. So those are all the things for you to know. Duration of the marriage matters. Another big factor is going to be the financial situation of each spouse. So if you are making $300,000 a year and you're working full time and your spouse has been a stay-at-home parent and they don't have any income and they're going to have to go back to work, you are going to financially recover faster from the divorce than they are. So they're probably going to get more of the community property than you. Okay, that's one thing to know. A financially disadvantaged spouse in a longer marriage is probably going to get more of the property. Not always, but that's kind of how it works. Duration of the marriage is important. Financial situation of the spouse at the time of divorce is important. And also future earning potential is important. Those are the kind of the primary things. So you could have community property divided 60-40, 50-50, 52-48, 70-30, all kinds of different divisions are possible, but they're all very fact specific, which is why it can make a big difference, especially if you look at what a percentage of your community is worth, right? So it's really important that you are important. It's important that you're intentional and that you are well informed when you're going to make a decision. I've had people come to me where they think it's all worked out and they're like, oh, hey, we decided to split everything 50-50. Here's the orders that we came up with in this mediation without attorneys. Can you guys draft it and sign off on it? And I'll be like, well, yeah, but if you're taking 50-50 and you were probably, that's your worst day and no court would give you that and you're going to get 60-40 and each percentage of your community is worth conservatively $10,000, you just gave away $100,000. Was that really smart? No, you probably should get an attorney and that's a good return on investment. Or I had one once where somebody felt really good about it and they came to me and it was actually almost a $600,000 difference. So guess what? They change their mind. So anyway, these are things for you to keep in mind. So that's a little bit about division of community property. The last thing I will mention is separate property usually stays with the original owner. There is an exception to that. Separate property, if you change it and make it community property, put your spouse on, a separate property asset with the intent to make it community, or you start putting separate property money into community accounts and spending it out of there. You could commingle it. There's ways to change it, but generally it stays with that person, unless it's a long-term marriage of 25 years or more, where that dividing line between separate and community kind of disappears, and separate property can be what we call invaded and given to either party to do equity. So that's a little bit about that. I can move on to talking about the next issue, which is spousal maintenance, but Melissa, any questions before I do?
Yes, there are a couple. Somebody's asking, what happens if a spouse leaves their job on purpose just to try to get more shares of the property? Is You're to come out ahead in asset division. Is that something that happens, or, or how does the court contend with that?
Yeah. So if you are, that leads into spousal maintenance. If somebody is voluntarily unemployed or underemployed, that's different than I got fired from my job. I tried to get another one. The market's really tough and I have been looking and I can show that I'm not getting anything. If someone quits their job because they want to be the financially disadvantaged spouse, that's not going to cut it. The court can do what it's called imputing income to you. So what that means is they can say, oh, what's your last known income? How long were you making that? What are the circumstances surrounding you losing your job or leaving your job? And they can say, well, you're imputed. You should have that income. So it doesn't necessarily work. You do need an attorney to help you kind of sometimes make that argument, or it's not as obvious. But imputation of income is a thing for spousal maintenance and child support. Somebody doesn't get to quit their job because they don't want to pay you spousal support or because they want to get more of the property. It doesn't work that way. There are people that will make that attempt all the time, but that's pretty usually transparent if somebody's doing that. Does that make sense? I hope so. Okay. And one more I can take before I move on.
Yeah, I guess it's along similar lines, but they're wondering, what if your spouse is hiding access to finances?
Well, that's why you need to get an attorney, because they have to make mandatory disclosure of all debts and assets. And if they don't, there is what's called the discovery process to seek disclosure of debts and assets, where they have to provide it. And then if they don't, they can be compelled by the court to do it, and they can be fined, and they can have to pay your attorney fees. And if they still don't, then your attorney has subpoena power to subpoena those accounts directly and get them. And if that happens and they've lied about it, then they're really in trouble. I've had that happen before, where someone's like, oh, I don't have any accounts. Well, we sent out subpoenas to 10 different banks, and oh my gosh, yes, you do. So there's also in most every competent settlement agreement a provision that says if somebody doesn't disclose something and it gets found later, it gets divided heavily in favor of the other spouse. So there are ways, it's almost in this electronic era impossible to really hide money. The way people can hide money is to do something like, oh, I'm putting, I get paid in cash and I'm holding it somewhere. But that's pretty rare, especially today when we have things like Cash App and Venmo, and even people that typically used to get paid in cash are not anymore. So something for you to think about. Okay. I will touch on spousal support briefly, and before I move on to parenting plans and child support. So spousal support. This is in Washington, it's called spousal support or spousal maintenance. In other states, it's called alimony. So it's the same thing. If you hear somebody mention alimony, that's what it is. It's not automatic. There are a number of factors in Washington that are considered. We don't have like a standard calculator where you plug in how much people make. We have that for child support. We don't have that for spousal support. There's general guidelines, and it's a very fact-specific analysis as well. Length of the marriage, just like property division, length of the marriage is going to be really important to consider. There's a typical ratio. Every 3 to 4 years of marriage is very generally 1 year of spousal support in a midterm marriage. In short-term marriages of 5 years or less, there's very often no support unless it's temporary or maybe like a year exiting the marriage. The reason for that is that in a short-term marriage, the principle is that nobody's relied on the community long enough, and people should be back in the position that they started in. It's backward looking. Short-term marriage, backward looking, maybe 50-50 property division and no maintenance, maybe 50-50 and a little maintenance, maybe 52-48, but pretty close to just let's put you guys back where you started, split everything and move on. Midterm marriage, though, spousal maintenance is extremely common in midterm marriages, unless people have the same resources. Length of marriage, each spouse's financial potential at the time, the resources and their earning ability. Does one person have a bunch of separate property or not? The age and health of each spouse. Are you getting divorced at 40 when you've got a lot of working years left, or are you getting divorced at 63, right? Like, so those factors matter. So 3 or 4 years of maintenance is often 1 year of post-divorce support. There's also temporary support that's available while a divorce is going on. So there's two different types of support. And no, if you pay temporary support, it's generally not attributable to counting towards your post-divorce support. Sometimes in a short-term marriage, a court will do that and say, hey, you already paid for 6 months. That's way more than this person would get post-divorce, so we're good. Other times, most of the time they won't. Long-term marriages of 25 years or more may result in long-term or permanent spousal support because there's a principle in long-term marriage and a line of cases that dictate, and that's 25 years or more, that dictate parties being equalized. But that can also really depend on working years left, Social Security benefits, and equalizing into perpetuity and what that really looks like, as well as the amount of the community. There also has to be ability to pay. So just because someone has a need, if the other person has no ability to pay, they're not getting support. So it's a fact-specific analysis, and you really don't want to leave money on the table. And on the other side of that, you don't want to be paying too much. So I had someone come and think they had to pay, I mean, they're married 12 years. They thought they had to pay 6 years of maintenance, like 2-to-1 ratio. That would never happen. Absolutely not. So those kind of things are really important to know. So that's a little bit about spousal maintenance, which I would say is the second basic in Washington divorce. And Melissa, I could take a couple of questions right now.
Yeah, so another person's talking about saying that their spouse moved their shared investment account under an account with only his name and the children. And it sounds like she's concerned about making sure he doesn't liquidate their investments.
Well, if you haven't filed for divorce, you should, if you're going to do it, because if you do, an automatic temporary financial restraint will go into place. It's automatically issued in every divorce case that says neither party can buy, sell, transfer, or otherwise encumber property outside of the ordinary course of business. So that means if he sells and liquidates, he's in big trouble, and there's a restriction that he cannot do that. Right now, he could, and you can't do anything about it. The only thing you could do is then do an accounting backwards and try to say he should repay the community that money. It doesn't change it if he took your name off of it. It's still your money. Like I said earlier, it's still community property. It's still your money. You just don't have access to it. So if you need some protection, you should consider filing to get an automatic financial restraint in place so you have some accountability. And so he's in contempt of that order if he does something like liquidate it and is going to have to make it right. Otherwise, it doesn't mean you can't be made whole later, but it's going to take a bit more work. And honestly, it's going to be more expensive for you. So I hope that helps.
Yeah.
One
Yeah, a
more.
couple of questions. This person's asking, is it possible to have your spouse pay your attorney fees? Sounds like in this case, the spouse has been financially in control. This person doesn't have access to the family funds and that has been the primary caretaker to the kids and also has a much lower income.
Yeah.
So in that case, would it make sense or how would it work to have the spouse pay attorney fees?
Yeah, we should talk about that briefly. That's usually one of the last things I talk about, but I'll front load it and talk about it now. Attorney fees in Washington can be awarded based on need and ability to pay. If you have a need and the other party has the ability to pay, you might have a chance to get attorney fees. It can also be awarded based on intransigence, which means one person acts in bad faith during the divorce process. Need and ability to pay is the most common way to get attorney fees. Generally, though, speaking, you're going to need to get access to some funds to get started. Maybe you need to put it on a credit card. You can use a community credit card. Maybe you need to have a friend or family member get involved and pay an initial advance fee deposit for you. Maybe you need to get a personal loan. Maybe you need to open a credit card on your own, whatever it is. And then once you do that, then you have representation, and then you can seek having your spouse pay attorney fees to get you further into the case. Or sometimes what happens is if there's a community resource, the community might be able to pay funds for both spouses, fees for both spouses. That automatic temporary financial restraint does not apply to attorney fees. It's recognized that parties need legal representation. So you can use community resources or your own resources, however you want, for attorney fees. But you're probably going to need some help to get started. But then your attorney can seek fees from the other party and do that relatively quickly, and you'll have an answer on what's going to happen there, and also get you the financial transparency that you need. There might be community funds that can be used. So that's super important. That's not an uncommon situation. Unfortunately, that's a very common situation. One party is holding tightly to the money. You don't have access or you don't know what there is. And you're like, well, what do I do? Well, if they have an attorney or the means to get one, you're getting one too. So that's pretty important. Hopefully that helps. I will move on and talk briefly about child support. Actually, I'll talk about parenting plans. One more financial question, if there is one, before I move on.
Yep. Um, if I save money in my child's 529 plan, will the funds in that account be considered community property?
They're community property, but they're not subject to division. They'll stay with your child. They'll stay with the party whose name is on the account. They won't be divided. it's still community property because all property is before the court. But the amount isn't going to count against one party or the other as far as the division. So it's going to stay for benefit of the child. Yeah.
One more quick one. This person's talking about how their spouse has equipment, like business equipment, stored in
Mhm.
a parent's property. How would they find out how much it's worth?
You'd have to get it appraised. It's personal property. This is one thing I should drop about personal property. Personal property, I had somebody that spent like $15,000 on a sofa once, and they're like, well, I want half of that money for the sofa. Then they found out, well, no, you're going to get a garage sale value. Someone's going to give you 200 bucks for that sofa at the most. So property in general, unless it's appraised, like equipment, artwork, jewelry, or vehicles, unless it's something that can be appraised like that. In this case, maybe it is if it's business machinery. If you can't get an appraisal or real value on it, it's just garage sale value. Like household goods are all garage sale value. So you could do a request for inspection on it. You could get an appraisal on it. You could look at comparables and get an opinion on it, but you're going to need something to substantiate the value and make sure it's worth it. Good question. Okay, I'm going to talk about parenting plans. Parenting plans are what determine the physical and legal custody of your child. We don't really use the term custody in Washington. We use more friendly term like parenting plan, not custody order, residential schedule, not custody order, things like that. But that's basically what it means. In a parenting plan, the decisions in that parenting plan are based on what is in the best interest of your child or children. That is going to include a residential schedule, where your kids live when. That's going to include a holiday schedule, where your kids are on school breaks, holidays. It's going to include vacation time, like in the summer. It's going to include, whether that's the same as school year, different schedule, all of that. So the residential and holiday and vacation schedules. It's also going to include decision making. So who's going to have decision making authority over non-emergency medical, orthodontia, therapy, regular appointments, things like that, non-emergencies. It's well established that parents can make emergency medical decisions while the child's in their care. So we're not talking about your kid falls down, you have to have the agreement to go fix their broken leg. No, you can do that. This is more like, I need to schedule a well child exam. I want to put my child in therapy. Those are non-emergency decisions. Who's going to make those and how? Decision-making authority. That's one thing. The other thing is the types of dispute resolution, and we'll talk about that in a minute. How to work through dispute resolution. How does that look? What does that look like? How are you going to make decisions if you don't agree? There will need to be a dispute resolution method in the parenting plan. So your schedules, your decision making, your dispute resolution. There also needs to be transportation provision in there. Who's going to pick up and drop off? Where? Are the exchanges at school? Are they at the parents' homes? Are they at a neutral third-party location? All that will need to be in there. Then there's other provisions like out-of-state travel, international travel, access to records, all kinds of provisions like that. So it's a really important document. Your schedule for your kids, like I said, and all decisions in your plan are supposed to be based on on what's in the best interest of your child. However, sometimes logistics come into play. You might have, a great co-parenting relationship and want to do a 50-50 shared parenting plan. But if one party lives in Everett and one lives in Bellevue or Tacoma, that's not going to happen. You don't live close enough together to do a shared schedule like that. The age of your children is going to matter too. Residential schedules are heavily dependent on what's developmentally appropriate. A schedule for a 3-year-old is going to be different than a schedule for a 12-year-old. It makes sense a lot of the time to have a stepped parenting plan if your kids are really young, to how the plan could transition to different phases as they get older. So sometimes that's going to be important as well. So those are some basics for you to know. It's also important for you to know that there is what you would call joint legal custody, where both parents share responsibilities in residential time, no matter how that's split up. And then you have physical custody, which is who has the kids at that given time. Okay. Courts favor continuing contact with both parents unless there is a restriction. A restriction can be a restriction in your plan for substance abuse that has a nexus to the parenting, mental health, if there's a nexus to the parenting and it impedes your ability to parent, domestic violence. If finding a domestic violence is an automatic restriction in your parenting plan as far as decision making, no dispute resolution aside from court intervention, and limited time with your child. So restrictions can be really, really important, and whether your case qualifies for one is something you would need to do an evaluation on. Okay, last thing I will say about parenting plans before we take questions is this. Custody evaluations. A lot of the time, if you do not have an agreement on parenting, there will be a need for a custody evaluator. That can be a guardian ad litem, a parenting evaluator, family court services, a court-appointed special advocate. Depends on your situation and what the needs are. All of those people will generally talk to third-party contacts, people like your therapist, your friends that you mentioned, who else is involved with the kids therapist, all that kind of stuff. It's really important that you consider having your own therapist as you go through a divorce, whether you have contentious custody or not, but especially if you do. It's good for your mental health. It's something that reflects positively on you, and it helps you cope with a really stressful situation. So, any questions on that?
There's a few questions here, but they're not really on the same topic. So I don't know if you
Okay.
want to.
Yeah,
Okay.
I'll take a couple more, then I'm going to move on to child support.
Okay. Um, this person's talking about how, they're in a situation where their spouse wants them to leave the home. And they're wondering if they can be forced out. They see it as a shared investment. Obviously, it is a shared investment. You talked a little bit about it earlier, but they are also concerned about, how even if they do choose to leave the toxic situation, it could, have less of a hold on their portion of the investment. You mentioned that earlier, but can they be forced to leave the home?
Yes, you can. It doesn't, basically, if one party or the other goes to the court and asks for a temporary order for them to have temporary custody of the home, court's almost always going to grant it. They don't want two people living together during a divorce, especially if one party is saying it's contentious. If the parties are getting along great and I live upstairs and you live downstairs and we're fine and making it work, perfect. No one's going to force you out. But if one party goes to the court and says, you know, this is tense, this party can afford to live elsewhere, and I want to have temporary control of the home. Yes, most of the time the court will order you out. So I'm not saying they'll order you out. You could also try to get the other party out, depending on what the circumstances are. But it's really smart to act first if that's your situation, because you're probably going to prevail absent other circumstances. Domestic violence and restraining orders are also immediate actions that sometimes are taken to have the other party removed from the home. So, but yes, to answer your question, you can be ordered out. It definitely can happen. So,
And then another question, how about monthly adoption income? Is that community property?
yeah, I mean, yeah, if it's money coming in and it's an adoption subsidy for your child, yeah, definitely.
And then the last question I have here is if two vehicles are in a spouse's name, how does that work when dividing, especially if a non-working spouse can't actually afford a car payment?
Well, if you can't afford a car payment, the other party can. That's kind of where parties do financial declarations that are exchanged, and you determine do you need spousal support to afford basics? But it doesn't matter whose name they're in. One thing that can matter though is if you're not able to refinance a car into your name and there's a loan on it, maybe part of the negotiation will need to be having it paid off the car that you take, or having the other spouse stay on title on the car longer to allow you to take it over or pay it off. So it doesn't mean you don't have an interest in it. And if you can't afford a car payment, that needs to be addressed in the property division and the spousal maintenance. So,
Yeah. Okay.
something to think about. Child support, I want to make sure we talk about
Yeah.
that before we run out of time. Child support is the fourth main issue. I guess there's five if you talk about attorney fees. We talked about that already. But the main four issues are asset and debt division, spousal support, whether it applies, parenting plan, and child support. So child support, basically Washington uses a standardized formula. So we have a formula that's based on the parent's income, number of children, and who has more time with the child. It's not by night, it's just who's the primary parent. So basically you do a calculation that the state does. We have a calculator for it based on the income of the parties. And the child support transfer payment caps out at a combined income of $12,000 a month. So you could seek a deviation for more or a deviation for less, but generally there's a standard calculation, and deviating from that is not automatic. There can be reasons to, but it's not automatic. Payments continue until a child turns 18 or graduate from high school, whatever's later, and adjustments can be made every 2 years based on income. Somebody can go and get an adjustment just based on income. They can do a modification at any time based on significant life changes, losing a job, not being able to get another one, becoming disabled, things like that can be a basis for modification. Post-secondary child support for college You need to seek that by the time the child is 18 or graduates from high school, whichever is last. If you don't, then it's gone and you cannot seek post-secondary support to require one party to contribute to the child's education. So that is all very important. There's two components of child support. There's the transfer payment made from one parent to the other, the parent that has less nights to the primary parent. If you have an equal parenting plan and incomes are equal, there might be no support. If you have an equal parenting plan and one parent makes a lot more, there probably still will be child support, although it might deviate down for one party having a lot of nights too. It all, again, that depends on your situation. The thing for you to know is, in addition to that transfer payment, there's what we call proportional or pro rata share, which is your individual percentage of the child support amount. And that's going to be what you pay for things like out-of-pocket medical co-pays, braces, things not covered by insurance, work-related childcare. You guys have to share in that cost. That's going to be a proportional cost as well. So those are kind of the big ones. Extracurricular activities is another big one. Child's playing soccer. Okay, I make 75% of the income. I'm paying 75%. Other party makes 25, they're paying 25%. So those numbers are very important. And like I said, they can be adjusted every 2 years for income or more frequently on a substantial change in circumstances, although that's a pretty high bar. So I hope that that is helpful. I can take a few more questions and then I'm going to tell you a little bit about the process.
Yeah, I just have one more question here right now. It's kind of general, but just in terms of safety. If people are concerned that their safety is at risk, that their life is at risk, if there's some sort of a domestic violence situation, and we're talking about kind of leaving the home or not leaving the home, or
The
seeking.
home, like leave the home and get a protection order. That's really, if you're worried about your physical safety, get the heck out of the home.
Yeah.
Like, you're not giving up any rights to the home and there's no reason for you to be there, or get the other party out of the home if that's what you need to do. Domestic violence protection order is something that's available to you if the other party has committed domestic violence. Domestic violence in Washington doesn't just mean I put my hands on you or I physically hurt you. It can mean coercive control. It can mean, which can be a lot of things, financial control. It can be emotional. It can be someone constantly having suicidal ideation as a means of controlling you. But it can be fear or imminent fear of bodily harm because of threats someone has made. So you need to find out if you're in that kind of situation, or if you're really scared for your physical safety. You might be able to get a protection order to protect you right away and get the other party out of the home, or you can leave the home. You might be able to get a restraining order, even if it's not a DV situation, but it's still an imminent harm situation. So you have options, but don't stay in a situation that is not safe for you. Absolutely.
Thank you.
Or if you have kids, especially.
Yeah.
What's that? Yeah.
Yeah, couldn't agree more, really. And make sure that you have adequate support if you are in a situation where you're feeling like your, life or your safety is at risk, and, get out, protect your physical safety, and also your mental well-being and your emotional well-being, is taking a toll. So make sure you have adequate support.
Absolutely. Yeah, that's 100%. And it can be very difficult to take that first step, but taking that first step is important, and getting the support in doing it is important. A little bit about the divorce process in Washington. The process can start one of a couple of ways. The most common is somebody files a petition and they have it served on the other party, or the other party accepts service. Very often we won't just send a process server. If the parties are getting along, we'll send it to the other party, save the cost on that, and let them sign an acceptance of service. If they don't, then we can send a process server. So that's typically how things start. Sometimes things start with negotiation. You're able to negotiate before filing, although that's not really common. It kind of makes sense a lot of the time to file, establish that date of separation, and start the discovery and negotiation process. After you file, there is usually a negotiation that goes on. Sometimes that's in mediation. Sometimes that is on your own. Sometimes that is through attorneys. The way that that looks can vary. And then very often there are what are called temporary orders. In temporary orders, you might go to court or you might agree on them. And that puts temporary orders in place, like a new status quo. Who's going to pay what bills temporarily, that are community bills or their own bills? Who's going to live where? Like, people are asking about leaving the home. Who's going to stay in the home? Who's going to be out? Right? And that's what I was talking about earlier. If somebody seeks some temporary orders, then you might be moving out. So temporary orders is going to be who has the home temporarily, who's paying temporary spousal support, who's paying temporary child support, where are the kids living temporarily, who's making decisions temporarily. All of those things come under temporary orders, and that can happen very soon after you file your case. Sometimes in starting a case, like I said, you might get a protection order or restraining order at the beginning of the case, if you are scared to proceed with the process and you need some adequate protection given the history of the case. So that can happen. Then you might have temporary orders. You might then have custody evaluators. You might might engage in the discovery process on financials. There's a lot of things that need to happen before you get to the end and participate in a mediation where hopefully your case settles. And if not there, then you go on to trial. Less than 10% of divorce cases go to trial. Even really contentious family law cases very often settle in a mediation. And a mediation, just to touch on that, isn't what you might think where everybody's sitting around a table and talking. That's not a mediation. I mean, you could do it that way, but that's not usually how attorney-led mediation works. We utilize a shuttle mediation format where you're in one room with your attorney, they're in the other room with theirs. It could be virtually on Zoom, it could be in person, and the neutral attorney mediator shuttles back and forth between the rooms, carrying offers and doing an evaluation of the party's situation to help bring them closer together. It's extremely effective. You have privacy for negotiations. You get to vent a little bit, and you get an independent evaluation of your case. It almost always settles the case. So that is something to think about. It's very cost effective compared to a trial. The other means of alternative dispute resolution include arbitration, which is having an arbitrator make decisions for you either on writing or on testimony. Collaborative divorce, which is a whole other type of divorce that you can do, which is typically not right for everyone, or like I'm talking about a cooperative divorce with negotiation through counsel. So those are a lot of basics that I think I've given you. You have the four main issues. You have the idea of attorney fees. We've touched a little bit on protection orders. Yeah, we've talked about staying in the home versus not staying in the home. So hopefully this has given you a solid foundation. We will do foundations webinars every month. So if you want to come back, some of it will be the same content. It's always a little different based on the questions that you ask. So I hope that that is helpful for you. We also do a special topics webinar. You can access those on our website by going to our YouTube channel, and you can sign up to get invites for future webinars. We do one every month if you're on our mailing list that might be a special topic. Maybe it's about relocation, maybe it's just about financials, maybe it's about custody, all kinds of stuff. So anyway, this was meant to be an overview. I really hope this was helpful for you, and that you took something away from it. So thanks for coming. Thanks for participating and being part of our community. Melissa will put some contact information up for you, and we hope to see you next time. Take care. Bye-bye.
Yeah, thanks for joining us, everyone. Really helpful when you show up and ask questions. Sometimes you ask something that somebody else didn't think to ask, but would have really appreciated getting the information. So it's really helpful to have people participate. We appreciate it. I'm going to leave the contact information here for just a moment. Somebody's asking if there's a recording. Yes, there will be a recording. It'll be available on our YouTube channel. And again, Michelle's going to be continuing to run these webinars. We'll be running these webinars every month. So come back again, ask more questions, and we'll be continuing to be here to deliver that information. Feel free to reach out to Michelle's firm, Dellino Family Law Group, if you're interested in having a consultation with one of the attorneys. If anyone's interested in counseling services, my information is there as well. I will leave it up here for a few more moments, and we hope to see you again soon. Take care.